It is 5:47 in the morning. Your flight back to the United States boards in 40 minutes. You have your green card in your hand. You have your boarding pass. You have your bags. You did everything right. And then the airline agent at the counter looks at her screen, types something, looks at you, and says the 6 words that will stop your heart cold. "Sir, I cannot check you in." You ask why. She turns the screen slightly and you see a red flag next to your name. She picks up her phone. You do not know who she is calling. Your hands are shaking. Your family is waiting for you in New Jersey. Your job starts Monday. And right now, in this foreign airport, you are completely frozen because you do not know if you are about to be turned away, detained, or worse. This is not a story I made up. This is what is happening right now to real green card holders, real visa holders, real people who thought they were safe. People who never missed a court date, never violated their status, never did anything wrong. And the reason it is happening is because most immigrants have no idea what changed, what the new rules actually say, and more importantly, what their legal rights are the moment something goes wrong at a border, an airport, or a checkpoint. What I am going to show you today is exactly what changed, why it is catching people off guard, and the exact legal shield you need to protect yourself before you travel anywhere in 2026. Stay with me because this information could literally save your immigration status. Here is why 90% of immigrants are getting this wrong. The mistake is not that they broke a rule. The mistake is that they trusted old information. They heard from a cousin, they saw a 30-second TikTok video, they read a Facebook post from someone calling themselves an immigration expert, and they assumed nothing major had changed. That assumption is now costing people everything. The Trump administration, through a combination of executive orders, DHS directives, and State Department guidance issued between late 2025 and early 2026, has put in place a new framework that affects who can travel internationally, who gets flagged on return, and what categories of visa holders and green card holders face enhanced screening or outright travel restrictions. And here is the dangerous part. The government is not going to call you. USCIS is not going to send you a personal letter. CBP is not going to email you a warning before you book that flight. You find out at the airport or you find out at the port of entry. And by then, your options are limited and your stress is at a level most people have never experienced in their lives. The trap is not just the new policy itself. The trap is the silence around it. The trap is the gap between what changed and what the average immigrant actually knows. And filling that gap is exactly what we are doing right now. Let me start with what the executive orders and DHS directives actually say, because the details matter enormously here. The Trump administration issued executive orders focused on what they call enhanced vetting and national security travel protocols. Under these orders, the State Department and the Department of Homeland Security were directed to expand the list of nationalities subject to additional scrutiny at the visa issuance stage and at the border. The initial travel ban that most people remember from the first Trump administration was a blunt instrument. What we are seeing in 2026 is more surgical. It targets specific nationalities, specific visa categories, and it also introduces something that many green card holders do not realize applies to them. A lawful permanent resident, meaning someone who holds a green card, is not automatically exempt from these new travel scrutiny protocols. Under INA Section 212, the Immigration and Nationality Act gives the government authority to make certain grounds of inadmissibility applicable even to returning lawful permanent residents under specific circumstances. That is the legal mechanism being used right now. It does not mean your green card is being canceled. It means that when you return from international travel, you may be subject to a level of review that was not happening 2 years ago. The specific nationalities facing the most significant restrictions as of early 2026 include countries that have been designated as either state sponsors of terrorism or countries identified in the executive order framework as presenting heightened national security risk. The current list includes Cuba, Venezuela, Haiti, Libya, Somalia, Sudan, Syria, Iran, North Korea, and Yemen, with DHS retaining the authority to add or modify the list at any time through administrative action without needing congressional approval. That last part is critical. This list can change without a vote. It can change while you are already on a plane. Now here is where the green card situation gets very specific and very serious. If you are a lawful permanent resident who was born in or holds citizenship from one of the flagged countries, you are not automatically barred from traveling. Your green card still has legal weight, but you are being processed under a different standard when you return. CBP officers at the port of entry have been given broader discretionary authority under the new DHS directives to conduct what they call extended secondary inspection, which means they can pull you out of the regular line, take your documents, and interview you for anywhere from 20 minutes to several hours without it constituting a formal detention. During that time, they can ask you about your travel history, your finances, your associations, your social media, and your purpose of travel. Under the Fourth Amendment, you do have constitutional protections, but here is the catch. Courts have consistently upheld that those protections are narrower at the border and at ports of entry than they are inside the country. CBP has broad authority at the border, understanding that reality is not about scaring you. It is about preparing you so that you do not say the wrong thing out of confusion or panic and accidentally create a problem that did not exist before you opened your mouth. For visa holders, the situation has additional layers. If you hold a non-immigrant visa, an H-1B, an F-1, a B-1, B-2, an O-1, or any other category, and you travel internationally, your visa does not guarantee you re-entry into the United States. This has always been technically true under the law, but it is now being enforced with a new level of seriousness. CBP has the authority under INA Section 221I and related provisions to revoke a visa. The State Department has been issuing visa revocations, in some cases, with very short or even no advance notice, particularly for nationals of the flagged countries. What this means practically is that a person can leave the United States with a perfectly valid visa, and while they are abroad, that visa can be revoked, and they may not know it until they try to board a return flight or until they arrive at a U.S. port of entry. If your visa is revoked while you are abroad, you cannot simply board the next plane home. You would need to apply for a new visa at a U.S. consulate or embassy in the country where you are located, which under current processing times and appointment availability could take weeks or months. Now let me deal directly with what social media is getting dangerously wrong about this situation, because the misinformation right now is at a level I have not seen in 6 years of doing this work. There are TikTok videos circulating that claim green card holders from any country can travel freely with no restrictions whatsoever, and that the new travel rules only apply to people on temporary visas. That is false. There are notarios, people with no legal qualifications, telling people in their communities that if you have been a green card holder for more than 5 years, you are completely protected from any travel scrutiny. That is also false. Continuous residence and long-term green card status are relevant to naturalization eligibility, but they do not create an immunity from CBP inspection at the border. There is also a rumor circulating heavily in some communities that the best strategy is to say as little as possible during CBP inspection, to the point of refusing to answer questions. That strategy is a serious mistake for green card holders specifically. While you do have Fifth Amendment rights, invoking them broadly as a green card holder at the border can result in CBP treating you as uncooperative, which can escalate a routine secondary inspection into something far more serious and can, in certain circumstances, affect your status. The correct approach is not silence. The correct approach is calm, prepared, truthful, and minimal engagement. There is a significant difference between those two things, and that difference can determine whether you walk out of the airport in 2 hours or spend your evening in a holding room. So let me give you the exact survival strategy, the action plan you need before you travel anywhere in 2026. Tonight, before you book any international flight, go to the CBP website and check the current I-94 records linked to your name. Your I-94 is your official arrival and departure record, and any discrepancy in that record can create complications at the border that have nothing to do with the new executive orders. They are just an administrative error that becomes a serious problem at the worst possible moment. Fix any errors before you travel, not after. Second, if you are a green card holder from any of the currently flagged nationalities, or if you hold citizenship in any of those countries, even if you also hold citizenship elsewhere, consult with a licensed immigration attorney before you travel. Not a notario, not a community paralegal, a licensed attorney. A 30-minute paid consultation before your trip could prevent a situation that costs you thousands of dollars and months of your life to resolve. Third, carry physical copies of every document that establishes your ties to the United States, your employment letter, your lease or mortgage statement, your most recent tax return transcript from the IRS, your children's school enrollment records if applicable. When a CBP officer asks you why you are returning to the United States, the answer is never just because I live here. The answer is a brief, clear, confident statement. I am a lawful permanent resident. I work for this company in this city. My family is here. Here is documentation of my employment and residence. Fourth, before you travel, screenshot and save the current State Department travel advisory for the country you are visiting and the current DHS published guidance on the countries subject to enhanced review. If there is any challenge to your re-entry, having documented proof that you checked the current official guidance before you traveled demonstrates good faith. Fifth, if you are an H-1B or other non-immigrant visa holder, contact your employer's immigration counsel or HR department before traveling internationally and ask them directly, is there any reason my visa could be at risk while I am abroad? Large employers with active immigration programs will know if there are any flags on your file or any pending issues with your petition that could create a problem at re-entry. Do not assume your employer would have told you. Ask directly. Sixth, if you are stopped at a port of entry and placed in secondary inspection, stay calm, answer the questions asked truthfully and briefly, and do not volunteer information beyond what is directly asked. If the situation escalates to the point where an officer suggests that you may be denied re-entry or that there is a formal proceeding, at that point, and only at that point, you can respectfully state that you wish to speak with an attorney before any formal action is taken. That is your right, and stating it clearly and calmly is not confrontational. It is simply you exercising a legal protection that exists for exactly this situation. My name is James. I am a senior immigration analyst with 6 years of experience. And on Immigration News Today, I do not give you opinions. I give you the survival strategies that keep families together. What we covered today is not a hypothetical future scenario. This is the current legal environment that you are navigating every single time you cross a border. The executive orders are signed, the DHS directives are in effect, the CBP officers at every port of entry have received updated guidance, and the difference between the person who walks through smoothly and the person who spends 6 hours in secondary inspection is almost always preparation. It is knowing what changed, knowing what rights you have, and knowing exactly what to say. That is what this channel exists to do. To make sure that the information you need to protect your family does not arrive too late. Immigration rules change overnight. A new executive order can be signed at any hour. A new country can be added to the flagged list before you even wake up tomorrow morning. Join my WhatsApp community for instant alerts before I post on YouTube. The link is in the description. You will receive updates the moment something changes so that you are never in that situation at the airport counter without knowing what happened. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration News Today right now and turn on notifications. Staying informed is no longer optional. It is essential. I am James. Protect your status, protect your family. I will see you in the next update.